Hello, and welcome to Conflict Conundrums, an introduction to legal ethics and conflicts of interest. A few questions for you. Representing both the husband and wife in estate planning? Assisting with the divorce of your favorite friends? Ouch. Asked to represent co-defendants or multiple family members in a criminal, personal injury, or immigration case? How about new clients want to pay you with stock in their enterprise? Conflicts of interest exist as a fundamental concern in the practice of law. If ignored or misunderstood, fundamental concerns can create significant problems for the unwary lawyer. So, what's a lawyer to do? Step 1, assess whether there's a conflict of interest. Step 2, analyze whether it's consentable or impermissible. Step 3, proceed accordingly. This course will explore these steps in the context of the conflict of interest rules and their applications in the everyday practice of law. Although we've previewed the simple sounding 3 steps to determining whether there's a conflict, let's break it down further. And I think the easiest way to understand conflicts and how they apply is to first define the type of client that you're talking about, or rather the status of the client. And what do I mean by that? We can divide clients into 3 main status types: the prospective client, the current client, and the former client. And depending upon which type of client you're dealing with, the conflict rules apply somewhat differently. Now, we're talking about legal ethics, so before we get to the actual numbers of the conflict rules, let me just lay out, to begin with, the fundamental rules for effective practice of law, effective and ethical. I usually point out are 1.1, and I'll be using the model rules here, which is competence, 1.3, which is diligence, and 1.4, which is communication, and 1.6, which is confidentiality. Now, there are many other important rules, but the bottom line is competence tells you you have to understand what you're doing, what type of client you're taking, the area of law that you're practicing, or be able to learn it. Diligence requires you not only to remain diligent in your ongoing education in the law, but it's focused on being diligent with your clients and your clients' cases. So you can see how the two kind of go hand in hand. Confidentiality is one of the underlying tenets of the attorney-client relationship. Some would say sacrosanct, and confidentiality extends beyond the attorney-client privilege, which is evidentiary in nature. Confidentiality has to do with everything you learn as part of a representation. And in that way, you can see that it's going to play a large role in determining conflicts of interest and how to proceed with them. So with those few rules as a foundation, let's proceed to discuss and define the 3 status types of client. The first type of client is referred to as a prospective client, meaning someone that is seeking advice perhaps, but may not become a full-fledged client. The description for prospective clients is found in Rule 1.18, and it talks about someone who may be seeking advice initially, but doesn't ultimately retain the lawyer, or the lawyer doesn't actually take the case.